Good evening, and welcome to the Illinois State Bar Association's program on military legal rights. I'm Nancy McKenna, and I'm your moderator tonight. I'm an attorney here in Illinois. To my immediate right is Jason Val. He's a senior attorney with the American Bar Association Division for Legal Services, and he serves as Chief Legal Counsel to the Standing Committee on Legal Assistance for Military Personnel. Jason works daily with the military legal assistance leadership of the 5 service branches to improve access to justice for military personnel and their families through educational programs, legislative advocacy, and the ongoing operation of the Military Pro Bono Project. He will be a speaker at the Points of Light Foundation 2012 National Conference on Volunteering and Service on June 17th and 18th in Chicago. To Jason's right is Frank Granard. He's currently an attorney with Johnson & Bell. He's licensed in 5 states, I might add, which is quite an accomplishment for an attorney. And most remarkably, he's a Vietnam War veteran. From 1964 through 1968 he served. Frank currently, and for quite some time, has been very active in the Department of Defense as a volunteer for the Employer Support for Guard and Reserve, as his shirt and emblem so ably indicate. And I thank you both for taking the time to talk to us today about military legal rights. Jason, I'll start with you. Are there any laws in Illinois that help protect military legal rights?
Well, sure. So the most powerful, and I think the most well-known statute is actually a federal statute, the Servicemembers Civil Relief Act, for which Illinois does have an equivalent statute that expands those federal rights even further. But the Servicemembers Civil Relief Act, the SCRA, is a federal law that was designed to recognize the fact that military members on active duty service, along with their families, they, as a condition of their service, face a number of challenges that are a part of serving in the nation's defense. And the law exists and was created to recognize those unique circumstances and to provide special protections and also rights to those service members to help accommodate them and to make their lives a little easier.
What exactly does the Servicemembers Civil Rights Act cover? What does it do for a veteran?
Sure. Well, the Act, the SCRA, typically referred to, is it's designed to do a couple of things, and I guess I could use a sort of an illustration, I guess, to kind of explain how it might work. As civilians in our sort of civilian employment, if say my boss said, I need you to transfer to an office in Japan, right? So if that were to happen, I could say, sure, I'll go ahead and do that, or I might say, well, that might not work for me. I think I might go find another job. At least theoretically I could do that. If you're in the military, you can't do that. If the military says you're moving across the country, or you're moving to Alaska or Guam or Japan or wherever it might be, you have to go. You have to pick up and go. And if you have a spouse, if you have children, if you want to keep your family together, everyone has to go. And so if you think about in your own life what kinds of challenges that might create for you, you think about things like, well, I have an apartment lease that I might have to get out of, or I might have an auto lease, or I might have a cell phone contract, or there are all kinds of things that go into that kind of a decision. But since a service member can't choose where they go or what they do, they have to have special protections that allow them to deal with those circumstances. So just as a basic example, they can terminate a lease with the landlord if they receive orders to move to another part of the world. And these rights actually extend even further beyond kind of the day-to-day things. If you think about perhaps if you were the custodial parent of a child and the other parent lived somewhere else, you would have to deal with that custody order if you were going to move to another part of the world. And so the SRA provides some accommodations there as well.
That would be very helpful. Does it just apply to the veteran asserting that right, or would it apply to the military personnel's spouse? One, if they have to ship out within 2 days and the spouse is left having to perhaps change the lease, or can't afford cable, or can't afford the cell phone, or they want to discontinue the spouse who's over in active duty, their cell phone, do they have the right to discharge their duties from the contract as well?
Sure. So the Act applies to all active duty military personnel. It also applies to reservists who are on active duty for 30 days or more, as well as National Guard service members who are called to active duty either what called Title 10 federal orders, or even under Title 32 if it's an order from the President or Secretary of Defense for 30 days or more. So the protection extends to them as well as their dependents. So that can be a spouse, that can be anyone that the service member provides the majority of support to for, in fact, 180 days prior to the need to assert the right.
Would it apply to, if they certainly one of their dependents that's not a spouse, their children who they provide greater than 50% support to, would there be a situation where something that they perhaps were committed to by contract to assist the minor with, are there situations like that those types of contractual arrangements could be tuition perhaps, or is it more essential services like well, their health benefits would be covered by their military
Right.
service, but there are other types of situations besides a landlord-tenant arrangement, a simple contract that would involve their children that are dependents, that they would be able to discharge some duty there.
Right. Well, the statute does enumerate the specific areas in which the service member has the right to discharge contractual obligations, and as I mentioned at the outset, states like Illinois and other states may provide additional rights, and that will vary from state to state. But I do think it's important to note that the key thing with this statute is that it's not just that because of the service member's military service, the need arises to assert the right. But in fact, what the service member needs to show is that the service member is materially affected by military service, requiring them to assert the right. So
it can't be for a matter of convenience or a better financial rate. It has to be because the military service is materially affecting their ability to live up to a contractual obligation.
Exactly right.
Okay.
So, and I can give an example I think that illustrates that pretty well. Under the SCRA, if you have a pre-service mortgage obligation, so let's say you bought a home and then and you were in the reserves and you were activated and deployed overseas for more than 30 days, and as a result, because you're not working your civilian job, you're not making as much money, you're having trouble paying your mortgage, that kind of thing. The SCRA allows you to lower your interest rate to 6% on that mortgage obligation. And clearly in the example I gave you, you're materially affected by your military service. But if the opposite were true, if you in fact were making more money in your military service, for example, then potentially you might not be able to show that material effect of the military service, and you might not have the ability to assert the right.
How many, do you have a sense for the volume of how many people take protection under the statute where they assert that they're materially impacted?
Well, I don't have a sense of how many, but what I do know is that certainly in the civilian world, it's often not well understood what rights are available to service members. And we do know that we've seen a lot of issues, especially in the mortgage lending area, where banks and lenders may not understand that the service member is in fact entitled to an interest rate reduction when they're materially affected by military service. So I think that the thing that's most important is that service members understand what rights they have under the Act, and also certainly civilian companies and others who might fall under the Act understand what they're supposed to do under the law.
And that brings us to a question for you, Frank. When Jason referenced the civilians not being always aware of what rights military personnel have, what's your experience been with employers of people that perhaps were employed and then they're called to service, deployed, active, or reserve. Are civil employers always cognizant of certain rights in the employment situation in regards to military personnel?
Maybe yes and maybe no.
Okay.
The federal law we're talking about for employment rights is called USERRA, the Uniformed Services Employment and Reemployment Rights Act.
Okay.
That was a statute that has a fallback to World War II. It was most recently amended in 1994, and there were some additional amendments to it in 2008. But essentially what that statute does is it protects the employment rights of a person who goes into the military for active service, and during the time they're in the military, their job is protected, and when they get out from wherever their service is, then they have a period of time within which they can go back to their original employer and demand that job back, and they have a statutory right to that job.
What's the period of time that they have to demand their job back once their active duty is complete?
It really depends on how long they were away.
Okay.
If it's a period of service for under 14 days, it's the next business day they have to go back to work. If it's more than 30 days, they have, I believe it's 15 days after to go back. After 60 days of being deployed, then they have 30 days to go back, and then after 90 days, they have up to 90 days to go back after they return.
So the longer your deployment, the active deployment, or active duty, I don't know if I'm using the correct term, the longer time period, the longer time period that you have, statutorily. It seems like the statute increases the time to notify your employer that you would like to come back to the job. The longer you serve, the longer notice period you have, it appears.
Correct.
In all fairness.
And what's important to understand is we're really talking about two subsets of military. One subset is the active duty military, the people who enlist, decide they're going to make the military career, or enlist and they're in the military for a long period of time. The other are what we're seeing more and more of, and have seen a lot in the past few years, are the reserve units or the National Guard who get activated under federal orders. They then become part of the federal military, usually for a period of time of anywhere from 8 months to a year, and sometimes even a year and a half. And so the same rights that apply to the active duty military for their rights to have their job back apply to the reserve component. And it depends on whether they're under federal service or under state service. USERRA applies to federal service if the president orders the Illinois National Guard, for example, to be activated for service in Iraq or the Cape of Africa or Bosnia, where Illinois
or Oklahoma, where there
or
could be,
well, no, because that may or may not be federal.
Oh, okay.
And the reason
It has to be out of the country for it to be federal?
No, it has to be ordered by the president.
Okay.
So
Okay.
that's called Title 10. You heard the term Title 10 and Title 32. Title 10 is a federal law that applies to the active duty military.
Okay.
Title 32 is the federal law that applies to what they call the militia, which includes the organized guard.
Okay.
And so the president has a right to of course, command the active duty military, the Title 10, and then has a right to command the Title 32 Reserve and Guard if they're ordered into federal service.
Okay.
Now that's important because USERRA covers federal service, but there are, Illinois, for example, and a number of states have many USERRA laws that apply to people who are called up by the governor, for example, to assist with flood relief.
Okay.
Or to assist with tornado damage. And there are protections for persons who are employees within that state. Normally those, though, go to public employees. There isn't a lot of protection at the private employer level for people who are called up for that type of service.
So what I'm hearing you say is that there's the federal statute, but there's also states would have their own form of guard protection and military personnel protection in an employment situation that perhaps is different, but also could it supplement the federal law?
Yes, the federal law says this is the floor.
Okay.
But you can you can get more under a state law. Illinois, for example, is one of the most military-friendly states in the country. And that's because the administration has been very pro-military, and there are a number of additional protections that state law provides to persons who are in the Illinois Guard, for example, than would be provided in other states for people in that same situation. But your question initially began with, do employers understand the law? And I said maybe yes, maybe no. What the organization I'm involved in, called ESGR, the Employer Support for the Guard and Reserve, is a federally mandated program through the Department of Defense to do just that, to inform employers of what the federal law is for employment rights, to also inform service members what their rights and responsibilities are, because, for example, if they don't report back to work by a certain time period, then they no longer have a right to employment. And so that we have a number of people who go out to employers, explain USERRA law to them, and then a number of people who go to the military units and explain their rights and responsibilities to them. For example, last year, the national organization of ESGR has 4,500 volunteers, about 150 in Illinois, and that organization briefed 500,000 soldiers last year on what their responsibilities were, and about 130,000 employers on what their responsibilities and their rights were. So it's a two-way street. What we're trying to do from this organization is to bridge that gap so you don't have the butting of heads that you might otherwise have. And so do employers know what their responsibilities are? I think in the main, at the upper level of corporations, they do. Sometimes when you get down to the lower level supervisors, they may not, and they don't know what the laws are, and that's where we have the problems both between the servicemen and their employer, and with the Justice Department and the employer.
Now, do you have any, if an employer just isn't understanding it and not listening to the military person that is their employee, do you have any resources to help them along a legal avenue? If talking doesn't seem to work, do you refer them to a JAG? What do you do? What does your organization do, the ESGR?
From the military side, if we can't resolve a problem between a service member and their employer, we have ombudsmen, which essentially are people trying to arbitrate that dispute. If we can't do that, then the service member has a number of things they can do. I mean, they don't even have to come to ESGR if they don't want. They can go directly and hire a private attorney and sue their employer, or they can go to Department of Labor, which would then investigate, and if the Department of Labor feels there's been a violation of USERRA, then they can prosecute. There was civil prosecution, but they can go for consent decrees and damages and so forth. And the Department of Justice is very, very attuned to the responsibilities that employers have to their service members. But in addition to that, for example, with our organization, we have an 800 number in Washington, D.C., and a number of full-time staff. If a service member has a question about their employment rights, they can call and they will get guidance. If an employer has a question, they can call and they will get guidance. Plus, there's a website that the organization has. It's ESGR, for Employer Support for Guard and Reserve, and then it's .com or .mil or .org. They want to make sure they get all of those last little 3 digits in there, and they can go there, and there's tons of guidance on there. Plus, the Department of Labor has a very good website for veterans called, the Vets section, and that has guidance for both employers and employees. Nobody's out to trick an employer or to get an employer to do something in trouble. What we're trying to do is to get them to understand what they are required by law to do, and quite frankly, a lot of employers do a lot more than the law requires them to do, simply because they say they think it's right.
Yeah. So has your experience been with this organization, this volunteer organization, that most employers try to do the right thing, and particularly if they are misinformed as to what the law is in terms of the military personnel's rights, that when they're educated through a group such as yourself, that they typically want to rectify the situation and just do what is certainly required by law. They're not doing anything additional. Some may go above and beyond, as you indicated, but certainly are most employers responsive if they've had a misunderstanding of what their responsibilities and duties are under the federal statute that you referenced, that they act accordingly? Or are some a little slower to respond appropriately?
I don't think I've seen anyone who's been slower to respond appropriately unless they really, really feel they're right. Usually the ones who really, really feel they're right are the ones that wind up in court, and they're usually the ones that find out they're really, really wrong. And it's a lot harder to find out you're really, really wrong with a judgment against you from a
Right.
jury or with a consent decree being entered against you. One of the things we also do is we encourage the service members to give an award to their employers. There's a thing called a statement of support that we ask employers to sign, where what the employers do is say they support their employees who are in the Guard or Reserve. We also have the service members nominate their employers who they feel have helped them in their service for what's called a Patriot Act Award. And that then is given to them by the ESGR, usually with an ESGR and someone from the military presenting that award. And then there are a number of other awards that go up to what they call a Freedom Level Award, which is at the presidential level. And there are 12 people a year who are given that award from the nation based upon recommendations from service members. So surprisingly enough, the number of service members who recommend their employers, last year it was at 60-some thousand, because they really felt their employers were doing more than they had to do to assist them in their service. And now they've opened it up to spouses who then can nominate their employers for the assistance they've given to them as being a military spouse.
Oh, that's nice to hear.
And
Yeah.
the employers will assist the spouse, let them take time off, will have people help take care of their children, will understand they have to go to the ball game, and those are the people who we also want to recognize, because if it's easier for the family to be a military family, it's easier for the soldier or sailor to be a member of the military.
Any particular personal stories you've encountered that have been very touching to you in your involvement in this agency with the employer situation? Perhaps any recipients of the Freedom Medal, or any story that was most moving to you?
The one that sticks out to me the most was a farmer in Iowa who had a service member who was in the Iowa National Guard who was deployed to Iraq. And he had a wife and 2 children who stayed on the farm. They were farm workers. The farmer allowed them to stay in their house, and where he had usually charged them rent, didn't charge them rent for the year and a half that the service member was gone. While the service member was gone, the farmer every month would come in and fill a freezer with food. His wife would come in and make dinner for them once a week so the mother could have time with the kids. She would come and watch the kids so the wife could get out every once in a while. And so they did that the entire term of the deployment. And when the soldier came back, excuse me, although they were authorized to have 120 days leave, the employer said, take as long as you want, a year, 2 years, it doesn't matter. And he paid him during the entire time he was gone what he would have made had he still been there. The farmer had 2 employees, and he was one. And so when that went up for the Freedom Act Award, they said, you know, what more could a person have done than take
Right.
50% of their workforce, and then...
Especially a workforce that's very labor intensive.
Absolutely.
Yeah. Oh, and what did he say when they gave him the award?
He said he didn't think he deserved it because he was only serving his country, as was his employee.
We should have more employers like that. Well, that's what America should be is about. It should be
Absolutely.
about. Now, Jason, back to you. Any personal story that stands out in your mind with all your dedication to military rights? Any particular story or case that has you think is very telling about the goodness of the organizations that you've been involved in?
Well, the American Bar Association and my committee specifically, the LAMP committee, operates the ABA Military Pro Bono Project, which is a national, first of its kind pro bono program that connects active duty military members with pro bono attorneys around the country to provide them with representation in all kinds of civil matters, not just those falling under the Servicemembers Civil Relief Act, but anything that a service member needs help with. And we've had tremendous success with that program. Over 500 military members and their families have been helped in the last 3.5 years of operation of the program, and many of those are deployed overseas who are receiving services back here at home from attorneys who dedicate sometimes hundreds of hours pro bono to represent these service members in all kinds of matters. And I mean, there are so many stories, I don't even really know which to choose, but what I can say is that there's an incredible need for that kind of assistance for military members, because the services do provide military legal assistance services through the JAG offices. And that's, I work with those folks every day, and they provide tremendous service to their clients, but there's a limit to what they can do. They can't go into state court in many instances, for example.
And that's where the pro bono
And that's where the pro bono
project
project steps in, and these volunteers have stepped up and taken these cases and done just incredible work, and it's really inspiring.
Now, each of you, what would you like, if there's a veteran watching this program, and we hope there are, and if there's people that are actively in the military, more importantly, that's watching, what would you like them to know? What would you want them to be,
Sure.
to take away from this program?
Well, with regard to the SCRA, I would say that it's an incredibly powerful law that's designed to protect rights across the spectrum of legal issues, from contracts to court actions, to ensure that military members, their service doesn't interfere with their ability to participate in the legal system and to resolve disputes and all of that. So I think the most important thing is that they understand that those rights exist, and if they don't know what those rights are or feel like they need to know more, to find out. And there are a number of resources out there that they can turn to find that. And I would strongly encourage them to meet with a military legal assistance attorney to tell them more about their rights.
Thank you so much. On behalf of the Illinois State Bar Association, thank you for tuning in. We hope you found the information helpful, particularly those of you that are serving in the military. We hope that the organization that Frank's in, the employer support of the Guard and Reserve organization is out there for you, as well as the American Bar Association's Legal Assistant Pro Bono program. And these statutes are here to protect you. And thank you very much, and have a good evening.